All right, Samantha Rendon. All right. So this is being set for a hearing on the violation report. State, did you have a chance to review the violation report?
Yes, Judge.
All right, State, what are you going to be requesting?
Yes. Full tracking.
All right, she currently on GPS?
She's currently on GPS, Judge. That's correct.
Tracking only with 9 PM to 6 AM. curfew.
All right, so,
Or 6 AM to 9 PM.
9 PM to 6 AM.
No, 6 AM to 9 PM.
She has to be she cannot be outside the hours of 9 PM until 6 AM. That's correct.
all right, so why does she need that time frame?
I have a daughter, her doctor's appointments and stuff like that, and myself, but that was the only reason why they did open it up for me, was my daughter.
All right, so are you employed?
Yes, ma'am.
What do you do?
I mean, I'm unemployed, sorry.
All right, so you're unemployed.
Yes, ma'am.
So how old is your daughter?
She's 16 months.
All right, so then the thing you have with her is doctor's appointments?
Yes, ma'am.
And do you have a scheduled doctor's appointments?
No, ma'am, I don't.
So how do you know when she needs a doctor's appointment? All
Oh, they're scheduled, yes, ma'am.
right, so what are those scheduling appointments?
My head, I'm not sure.
At the time, you don't have the documentation
I don't.
with you.
I know she has one, tomorrow at 11.
And so do you have any other family members who live with you?
My sister, yes,
And how old is she?
25.
All right. So I don't understand then why it can't just be GPS partial for doctor's appointments.
GPS partial for, would that be fine? That would work with us, Your Honor. GPS partial.
All right,
for-
so we're gonna do GPS partial for medical appointments only.
Yes, Your Honor.
Is there anything else?
Nothing further from the defense, Your Honor.
All right, counsel, if you want to take a copy, make a copy of this, you can.
Yes, Your Honor. Definitely will. And then I'll give it to the clerks to put in the files.
All right, thank you.
Thank you, Your Honor.
Oh, let me add, I'll add that they waive the fees on here.
Oh, yes, thank you, Judge. I was gonna ask.
Hopefully they can read my writing.
Thank you, Your Honor. Appreciate it.
welcome.
Best of luck with jury trial.
All right, thank you. Oh, you know what, Renee?
Yes, Your Honor.
Just one second, let me add something else in there because they may say, well, it's her medical appointments.
Oh, yes.
So,
Clarified.
you're welcome.
Judge, I think that joke came around when Pee Wee Herman was out.
Mhm.
Remember that movie he did? I don't know if you remember it, but
Yes.
it was at the Alamo.
Oh, I remember that Pee
It was
Wee's
so
Big
good, the
Adventure.
movie That he went to the basement of the Alamo.
Okay. All right, who's here on Javier Herrera? Sean? I did not visit any of those places. And number, what page is Rendon on? All right, thank you. Oh, why I can't see this? And can you get in touch with Meredith Chacon?
So Robin was defined the NPR. Oh, and she got back to me.
All right, can you have managed sign counsel send someone over so they can speak to him? All right, so Vashon, my understanding, the person with the measles went to Texas State University in San Marcos, Twin Peaks Restaurant in San Marcos, University of Texas at San Antonio main campus, Tussauds Waxworks, Ripley's Believe It or Not, and Ripley's Illusion Lab in San Antonio, Mr. Krabby's Seafood in Live Oak, and Bucky's in New Braunfels. So Mr. Krabby's Seafood, is that named after a Krabby Shack from? It is? I've never been to Mr. Krabby's.
Well, wait 30 to 60 days.
30 to 60 days, okay.
I was thinking about maybe I need to get a booster. I don't remember
Yeah.
if I mean, I think
Do they have boosters for that?
they do have boosters.
Oh,
And they
okay.
said if you're born between like 57 and 67 or something like that, then you should get a booster. It wasn't as effective that time period.
No.
I just heard it before.
Well, I guess I need to get my booster. Mhm. I'm still working on my shingles.
You haven't taken it?
No,
It's 2 shots and it hurts.
I know. They tell me it's painful. All right, still have the Mac come over. Who is here by iPhone? All right, who's the person by iPhone? What's your name?
Hello,
Yes, what is your
Oh.
name?
Brittany Rendon.
Norma, is there somebody here for Brittany Rendon? Do you know your case number or SID number?
No, it's not for me. It's actually for my sister.
Samantha?
Yes.
All right, that case has been completed. She's here. She should be home shortly.
Okay, thank you.
All right, you're welcome. And Norma, Who is the attorney who is on Humberto Nunez? Because the MAC appointed someone. It's not supposed to be. My understanding is that the MAC came in on that day and appointed someone. So could you have MAC come back, please? All right, thank you. Could I see the file on Fenton, please?
Judge,
Yes.
I just want to make sure you're aware, his mother wrote the court a letter.
Mhm.
Are you aware of that regarding regarding where he's gonna live in the future? He had some real concern, well, she was concerned that the court might order him to house arrest or something at her house. She wants him.
Oh, no, he's going to, I mean, jury trial, so.
Yeah,
It'll
I
be-
understand.
Yes, okay.
On top, that's the on top.
I'm sorry. The only ones I have Javier Herrera,
Matt,
Okay.
let me go take it with him, or you'll be waiting outside.
Alexander Rangel, and Mario Hernandez. Sure. All right, excuse me, miss. What's her name? Excuse me, what's your name? All right, do you have a case on the docket?
No.
All right, are you a witness? All right, you're excused from the courtroom.
Well, go ahead.
And who was the person who was communicating with the person in the audience? You know you're not supposed to do that. She claimed you as as her boyfriend. So who's her boyfriend? All right, you know you're not supposed to do that. Now she came downtown and she's not going to be able to see you for a long length of time because she's talking to you in the box. And the reason why that's done is for security reasons. The deputy doesn't know what that person's intention is towards you. You understand? All right, so next time I'll allow her to come back if you're here for another setting, but next time you can't talk to her, you understand? All right, thank you. Mr. Fenton, you need to make a decision on if you were found guilty, who you would come to for punishment, the court or the jury. If you do not sign saying who you would go to for punishment, automatically it comes to the court. So you need to fill that out. Oh, I'm not telling you anything. You're up for jury trial. Court is calling 2024 CR 011984 State versus Daniel Montoya. Could I have parties announced for the record? State, defense,
Arlene Gay for the defendant?
and are you Mr. Montoya?
Yes, ma'am.
Counsel, have you received all discovery and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Montoya, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
No, Your Honor. State will be proceeding as to count one only, and we will waive count two.
Any objection?
No objection.
Mr. Montoya, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could fine you and sentence you up to 20 years in prison and up to a $10,000 fine. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, he has assisted me.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he was.
Mr. Montoya, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at 2 years in the prison. There's a $500 fine, affirmative finding of deadly weapon. The state is silent on your application for deferred adjudication, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? All right, did you understand that to be your plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
All right, you're gonna have to speak up.
Yes, ma'am. Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
ma'am.
Counsel, are there any such motions?
No, ma'am.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers case exhibit 1 with all attachments.
No objection.
All right, state you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty. The court will defer finding of guilt. Just one moment. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Or are you requesting a PSI?
The court's gonna give him deferred, no PSI.
Well, this is the reason why I say that. I don't know if I'm gonna give him deferred or not, but the PSI, it takes about 8 weeks, so you'll probably be coming back in April. If you want to reset this for sentencing and bring whatever witnesses you want to bring, then I can have him come in sooner than that.
We can, I think we can waive the PSI and have a hearing. I think he has a story to tell. I think he's rehabilitating himself. He was at a lifetime recovery.
All right, so when do you want it brought back? 2 weeks?
I think 2 weeks.
All right, Ms. Ferguson, if we can bring this back in 2 weeks and probation, the PSI will be waived. It's just the week of March 10th is spring break for people.
Okay. March 17th is a Monday,
Yes,
and the week before is spring break.
yes.
Why don't we do it the 17th?
All right. All right, Ms. Ferguson, if you can put this for March 17th. All right, you're welcome. All right, and if you'll speak with probation before you leave. State on Fenton, have you all already done an acknowledgement of discovery?
I don't know, Judge.
All right, if you all can check to see if that's done. All right, thank you. And Deputy Laura, Deputy Mejia, we're gonna start with the jury at 2:30. And Mr. Hardy?
Yes.
If your attorney is found guilty, is he coming to the court for punishment or to the jury?
Judge, he refuses to make a decision. He keeps explaining that he doesn't understand. I've tried.
All right. So you'll be coming to the court for punishment then.
Thanks, Steve.
All right. Thank you, counsel. And State, are you gonna be proceeding on the indictment as presented?
Yes, Judge.
Okay. All right, State, each of you will have 20 minutes for voir dire. Who's here on Jose Gonzalez? Hello. Mr. Gonzalez, come forward. Thank you for dressing appropriately for court.
Welcome. Thank you.
All right, so where are we on discovery?
Which I think I have all the discovery I needed, but I had filed a motion for an appointment investigator on October 22nd. As I think you're aware, I had to take a leave.
Yes. So it's just being presented to the court today. Okay. All right, so before we get to that, State, did you tender an offer?
Your Honor, yes, we've been discussing offers back and forth.
All right, Norma, on this case, I need a plea deadline date for 30 days. All right, March 27th. And then I'll sign your order. All right. Once you sign the reset form, you're excused.
Thank you.
All right, thank you.
Thank you, Your Honor.
You're welcome. And what page is he on? Page 6. All righty, yes. Yes. Sure. All right, everyone, we're going to be taking a recess at 2:30 because the jury is going to be brought in. So everyone give me 5 minutes. Okay.
Yeah, I'm good with it.
Yes.
Jamie.
Yes, I do.
Okay.
Javier Herrera?
Yes, Your Honor.
Yes, come down. All right, today, I think, is your plea deadline date. Is that correct?
Yes.
You want a jury trial?
Yes, Your Honor.
All right, we'll bring you back over dressed tomorrow for jury trial.
Tomorrow?
Uh-huh,
Yes, Your Honor.
okay.
Thank you.
This trial shouldn't take that
Okay.
long.
Okay, we'll come back tomorrow.
All right. Deputy Laura, can you have him dressed for tomorrow?
Yes.
Yes, ma'am.
It's done. Court is calling 2024 CR 012760 State versus Jacaven Jones. Could I have parties announced for the record for the state?
Gallery for the state.
Defense?
George Schaefer for the defendant, Your Honor, may I have him come up?
Yes. And are you Mr. Jones?
Yes, ma'am.
Counsel, have you received all discovery in this case?
I have, Your Honor.
And did you review it with your client? Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Jones, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor. and-
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to proceed on the lesser included offense of theft from person, state jail felony.
Any objection?
No, Your Honor, we join the state in that request.
All right, did you review the document entitled Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state was proceeding on the lesser included offense of theft from a person as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent, and was legally sane at the time of the offense?
I do.
Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of theft from person. They're asking that your punishment be assessed at 8 months in the Bexar County Jail under 1244. There's a $1,000 fine and there's no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it? In both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, Your Honor.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State author states exhibit number 1 and attachments.
Any
No.
objections?
No objections.
And state, have you had contact with the complainant?
Yes, Your Honor, and they are in agreement with the author.
All right, thank you. You may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we could, please, Your Honor.
Anything you wish to say on behalf of your client?
For Your Honor, he did something stupid here. He stole 2 packs of cigarettes and a vape from the store.
Why are you doing this?
I heard purchase something that wasn't like this, so I just grabbed it like proof of point or whatever. I wasn't trying to.
Wait, I don't understand what you're saying.
I said I had bought something from him or whatever, and it was like basically like K2 I was told, so I just took a whole bunch of stuff like, cause I was mad, that's it. And I threw it out the window. I wasn't trying to hurt nobody though.
Well, here's the thing. You can't be doing that. Now, guess what? This is a felony on your record. Do you understand?
Yes, ma'am.
What are you planning on doing with the rest of your life?
Going to barber school.
All right. You better do it. Otherwise, there's always room at the jail. You understand?
I'm good on the jail. Been to there.
Did you love the Johnny Sacks? Food's not great. It's not. All right. Court is going to find you guilty, sentence you to 8 months in the state, 8 months in the Bexar County Jail. Under 1244, give you credit for any time served. There's $1,000 fine, time and money to run concurrent. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
No.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Do better.
Judge, she's got 135 days in jail. We would ask the court to give him credit for all of that, of course.
Oh, he'll receive credit for any time that he's been in custody. All right, thank you.
So.
Okay. All right, to the MAC. Where are they? To the persons on the MAC. From the MAC, from Managed Assigned Counsel. All right, you all came down and on a different date, and you all replaced someone for Humberto Nunez. You all gave him a new attorney, but I don't know who that is.
Yes, Your Honor. So it actually looks like our office had not made the reassignment based on the docket pulled today. So we're talking with counsel now, and definitely you've already arranged for new counsel.
Yes, and Mr. Liao, he's a Spanish speaker, so Mr. Liao in the courtroom.
Okay. All right, thank
He can
you.
speak to him or the-
All right,
And we
thank you.
apologize about that, Your
Oh,
Honor.
no problem.
Thought that was taken care of.
Oh, this is done. Could I see the file on Humberto Nunez, please? All right, just have a seat. Mr. Leal, are you going to talk to your client, Mr. Humberto Nunez? My understanding, you've just been appointed by manager to sign counsel.
I would, Judge.
All right, let's do it because jury's coming in at 2:30.
Turned in, yes, turned in. I'm sorry, to the far right. My bad.
Thank you, Deputy Laura.
I need more. I'm out here. Yeah, I'm thinking October. October is gonna probably be it.
But Charles, maybe we will have all retired and we'll be on vacation. Yes. You're welcome. Court is calling 2024 CR 008165 State versus Marcus Trammell. Can I have parties announced for the record? State,
And Harrison.
defense.
Charles Bunt for Mr. Trammell.
And are you Mr. Trammell? Counsel, have you received all discovery? Did you review it with your client?
We have, yes, Judge, I have and we have.
Court will find that the state is in compliance with discovery. Mr. Trammell, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
All right. All right, did you understand you're charged with threatening, terroristic threat? I don't know what this IMP stands for. Does anybody know what IMP stands for?
I don't know,
Something
but
public servant.
but I suspect it stands for impaired public service.
All right, so let's be sure that's what it means instead of we suspect. So you're charged with terroristic threat, and they're saying in the indictment that it was with intent to place the public or a substantial group of the public in fear of serious bodily injury. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Do you understand? If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He certainly does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I certainly do.
Mr. Trammell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state recommends deferred adjudication. Did you understand that to be the plea? Defense is at the plea?
Yes, Judge.
State is at the plea.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. And Bashan, are you ready? There's to be no contact with B as in boy, D as in Daniel, Holt Company, HOLT, Holt, Texas Limited, and all affiliated entities, Holt Group, including their owners, officers, and employees, included, but not limited to the following current and former employees. Michael Puryear, Puryear, Megan Lindberg, Lindberg, Becky Hutchinson, Beki, Jeff Stewart, Joy Jackson, Joyce Pingle, Pingle, Deanna Perez, Madison McNabb, Rosemary Gee, Sarah Scanlon, Pauline Tyler, Jessica Beers, Bearss, Brian Ramirez, Miko Roberto, Missy Grantham, Carissa Henry, Aja Kai, Aja Kai, Kalingal, Kallingal, Dan Norris, Peter Holt, and Karina Holt Richter, Richter. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead?
No contest.
State any evidence.
Contained in Exhibit 1 and attached.
No objections.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. And state, have you spoken to the complainant?
Yes, Judge.
All right, thank you, state. You may be excused. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We're prepared to proceed, Judge.
All right, and this was discussed off docket with defense counsel in the state. My understanding is that there's going to be a referral to Veterans Treatment Court.
Yes, Judge, we're hoping that the court will grant him deferred adjudication today. We have Veterans Court present in the courtroom with us. And we are going to further continue that discussion We believe he's an excellent candidate for Veterans Court. He served our country proudly, and it is his hope that he will be accepted into that program and have every reason to believe he's an excellent candidate for that program.
All right. So is there any fear from either party that of releasing Mr. Trammell before the,
Assessment.
yes,
I would actually prefer if he was released, Your Honor. It is completely up to you. I believe he's been in custody for a little bit, my understanding. So if he's out, we'll be able to get the necessary documents. We'll have him report to us on a frequent basis, so we'll let you know if we have any problem.
all right, and there's no fear for the safety of the community from either side?
Not from my side, Your Honor, and from speaking a little bit with the defense attorney, I don't foresee any issues.
State?
Not from the state.
All right, then what we'll do is the court will sentence you to 4 years deferred adjudication. There's to be a referral to VTC, regular reporting by Zoom or in person, regular random UAs. Out of custody, the following, TAP evaluation and a MIC evaluation. Of course, if you're accepted into Veterans Treatment Court, here you go, counsel. If you're accepted into Veterans Treatment Court, then Veterans Treatment Court will actually be supervising you, not this court. The only time you'll come back to me is if you want me to show up to your graduation, which I will, or if you're not doing well, okay?
Yes, ma'am.
All right, there's to be 200 hours of community service restitution. What do you do in your spare time?
Run a business.
I'm
Have
sorry?
my own LLC. I try to.
All right, what do you do
I'm a consultant.
for,
Uh,
I mean, what do you consult about?
I help the Army and the armed forces. I actually came up with the cure of cancer. I got an appraisal from NASA for helping improve some systems.
All right, so it's gonna be 200 hours of community service restitution. If there is something that you can suggest for his community service hours, I always keep an open mind on that, as long as it's something that is approving him and rehabilitating him.
Yes, Judge.
Do you have any children?
Yes.
And what are their ages?
25 and 19.
Okay. And there's gonna be field visits 1 time per month for 6 months. And I'll deduct 100 hours of his community service restitution if he when he completes anger management. And then there's to be no contact with the persons previously named. So that means you're not to go to the location at all or contact any of those persons that were previously stated. Do you understand?
Yes, ma'am.
Probation, is there anything else? All right, so there's to be proof of employment within 45 days of release, no employment as a home healthcare provider or with minors. Anything else, probation? Is there anything else you need from the court? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, in this court, to be successful, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to the court and I'll address it. Do you understand? Make sure that you keep up with your appointments with Veterans Treatment Court. So you're going to be released from custody. They'll probably release you sometime at midnight or 1 a.m. I have no control over that. And then what will happen is you'll set your appointment up with the VTC. All right.
Yes, ma'am.
All right. Thank you. Good luck to you. Just 1 second. I just have to put this in the system. And Vashon? If you need a copy of all those names, it's in here. All right, thank you. Yes.
Your Honor, I had a chance to speak with Mr. Bergen Savala. That was one of the cases that we were called over for. I
Yes.
believe Ron Zimmerman is the counsel of record.
Mhm.
After chatting with him, I do understand that Mr. Zimmerman was not at the previous setting as
Mhm.
well. But Mr. Zavala has good communication with
Oh,
him.
no,
and-
I'm fine with that. I just wanted
Okay.
to make sure that he knows, because sometimes people who are in custody, they get a little bit
So he's
upset.
actually out on bond. So,
Okay.
yeah, so he is here today,
Okay.
and that was my impression too. Initially, I
Yes.
thought he was going to be in custody, but no, he's out on bond, happy with representation. So I don't believe at this time changes are made, but if the court has any concerns, just give us a call and we're happy to.
All right, thank you. All right, Mr. Zavala, if you'll come forward. When do you want to call him back, Norma? For Ron Zimmerman? All right, you're coming back on March 3rd. All right, once you sign the reset form, you're excused.
Yes, ma'am.
Thank you.
God bless.
Thank you,
Oh,
Your Honor.
thank you. God bless you too. Oh, that's for anger management. Yeah. All right, so if they are ready, then we're gonna bring the jury in. Okay, all right, thank you. All right, in state, the Bergen Savala, that was set for a contested today, but the attorney is ill. To the pains. It's this one.
Oh, yeah.
Is that Zimmerman, Judge?
Yes.
Yeah.
Yes. All right, the people we have remaining are Tony Rodriguez, Miles Fenton, that's jury trial. Nunez, that's going to be a plea. And we have Robert James Thompson, that's with Leal. And then Mario Hernandez. We are waiting for that person to send back when he wants it recalled. And April Perez. All right, you're all up for jury trial as well. We're just seeing about this one.
Don't know where to go.
All right. Karen San Miguel. Yeah, her attorney is not here, so.
That's what, and I'll be down here.
Okay. All right, we have the interpreter. Oh, it's Mr. Leal's client, Mr. Nunez. I don't think, he hasn't been sworn in yet, has he?
Not yet, Judge.
Okay.
Yeah, this is not long. I've been on. Yeah.
All right, Charles, in your case, Tony Rodriguez, if this is if this is just that a bondsman has to be removed from the bond,
Yes,
then it appears that the bond should probably be set back at its original
yeah,
setting.
there was a surety to surrender back in December of 23 or something, so I'm just asking if you'll set the bond back at that amount.
All right, State, are you have any objection?
No, Judge.
That bond was 35, as it says in the motion, I think that bond was 35,000. Excuse me, 25,000, I'm sorry.
Well, he has two.
35.
One is the PF case. The PF case is different from the CR case, is that correct?
Yes, ma'am, but the PF case, I think, has since been indicted, since the filing of our motion.
All right, and so what was the previous bond on that one?
Are you talking about Judge PF 2024 PF 15325?
Yes.
The original is 25,000.
And then in the one that's 2024,
The original was 20,000.
all right, Mr. Rodriguez, if you'll come down, please. All right, Mr. Rodriguez, previously a magistrate set your bond and the cause number ended in 15325. They set it at $25,000. And the cause number ending in 9421, they set it at $20,000. The reason why you have no bond is because the bondsman no longer wish to be on your bond. Do you understand? All right. So my understanding from both parties, that is the only reason he doesn't have a bond. It wasn't that he violated bond conditions with the court. Is that correct?
That's my understanding.
Yes, Judge.
All right. So these are each drug cases. I still need to take you under oath, Mr. Rodriguez. We're going to go on the record in 2024 CR 009421 and 2025 CR 001529 State versus Tony Rodriguez. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Charles Bunk.
All right, Mr. Rodriguez, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Tony Rodriguez?
All right, in the past, have you ever been diagnosed with any mental health issues?
No.
Have you ever taken any type of medications for mental health?
No.
In the past, have you ever used any type of drugs?
Yes.
And what would that be?
Methamphetamine.
All right, and in the past, how often were you using?
I was every day, everything.
All right, so this is what the court is going to do. In cause number ending in 21, I'm gonna set your bond at $20,000. And I'm gonna order 120 sober meetings. In 120 days. And there will be regular UAs and I'll waive fees. Mr. Rodriguez, if you feel as though you need more to maintain your sobriety, let the court know and I can change conditions that can help you maintain your sobriety. It's not a punishment, it's for you to be
No,
clean and sober, okay?
I heard about lifetime. I don't want you
If you would like for me to put lifetime
No,
as,
Yeah, if I'm able to get out or whatever, of course, you know.
well, I can request also lifetime outpatient treatment. And so I'll say outpatient treatment
I mean,
with lifetime recovery.
Oh.
So you'll need to make sure you check in with them, okay?
okay,
And then in 2025 CR 001529, the court will set your bond at $25,000. There's to be 120 sober meetings in 120 days. Regular UAs, waive fees, and outpatient treatment with lifetime recovery. And Ms. Ferguson, can you give me a 30-day reset on these cases for discovery? All right, your discovery will be March 27th. And if you'll give him the reset form to sign.
Thank you, Judge.
All right, thank you.
May we be excused?
Yes. All right, court is calling 2024 CR 11670 State versus Humberto Nunez. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Rafael Leal for Mr. Nunez, Your Honor.
And are you Mr. Nunez? Yes. All right, we have an interpreter here. If you could raise your right hand for me. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, if you can lower your hand and state your name for the record.
Mariana Rios.
All right, Mr. Nunez, all of the documents are in English. Were these documents explained to you in Spanish?
Yes.
And Mr. Leal, do you speak Spanish?
Yes, sir.
And do you speak it fluently?
Yes, sir.
All right, Mr. Leal was appointed today by managed assigned counsel. Counsel, are you waiving your 10 days notice?
Yes, sir.
Mr. Nunez, do you understand that your attorney has 10 days to prepare for trial?
Yes.
And are you asking to proceed?
Yes.
All right. Counsel, you received all discovery?
Yes, sir.
Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Nunez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding with count one, waiving count two.
Any objection?
No objection, ma'am.
All right. Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
In count one, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine any witnesses the state will call and the right to remain silent.
Okay.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Did you intend to give up those rights
Yes.
and enter into this plea bargain agreement?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
It does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and was.
Mr. Nunez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promise you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
no,
Counsel, were you able to discuss with your client the immigration consequences of entering into a plea bargain agreement?
I did, Your Honor.
And did you inform him of deportation?
Informed me about deportation and the consequences of pleading guilty or no contest on a possession charge.
All right, Mr. Nunez, do you understand that by entering this plea, you can be deported from the United States
yes,
and that you will not be allowed re-entry into the United States?
yes,
And you'll be denied naturalization?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, state is proceeding on count one. Your punishment is to be assessed at 180 days in the Bexar County Jail under 1244. There's a $1,500 fine and there's no applications. Did you understand that to be the plea?
yes,
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you
Yes.
sign it in both places?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense in count one, how do you plead? Guilty, not guilty, or no contest?
Number four.
no contest,
State any evidence?
Yes, Your Honor. Exhibit number one with all its attachments.
No objection.
Did you review the waiver and consent with your attorney? Did you understand it and sign it in all the appropriate places?
yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
yes,
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulation. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client has accepted responsibility and we're asking that the court follows the agreement we made with the state.
All right. And are you here legally?
illegally,
All right. Then the court will find you guilty. The court will sentence you to 180 days in the Bexar County Jail under 1244. There's a $1,500 fine, time and money to run concurrent, give you credit for any time served, and there's to be no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
okay, yes,
All right, good luck to you.
Thank you, Judge.
Thank you.
thank you.
Thank you so much. All right, so. Is that Leal's client? Mr. Leal, you have Mr. Thompson in the box.
Yes, Your Honor. We need perhaps to reset and go. This is the first setting.
Could I see the? All right, Mr. Thompson, if you'll come down. How are you doing, Mr. Thompson? All right. So you have several counts, I believe, in your indictment. One is a possession less than a gram and the others are high-level felonies. So what I'm going to do is I'm going to reset this to give your attorney some time to look over the discovery and make sure that he has everything, okay? All right, so Ms. Ferguson, can you recall this back in 30 days? If your attorney wants you brought back over sooner than 30 days, we'll have you brought back sooner, okay? And the reason why I give 30 days is because one, you won't get lost in the system, and that will give your attorney more time to look things over, okay? All right, so we'll be back on March 31st, but if your attorney wants you brought back over sooner, we'll have you brought back over sooner, okay? All right, thank you. All right, and then Orlando, on yours. So it appears that this is going first. I'll put you on call for tomorrow just to see where we are on this. And then you have contact with your client?
I do.
All right, so we'll just have you on call for tomorrow and we'll see where this is. And if for some reason this falls apart, then you go. If it doesn't, then I'll have you call in and you all can confer on a jury trial date.
Okay, Judge.
All right, thank you. Do we have the numbers, the other numbers? Oh, for me to put the numbers over there. Oh, they're already out. Oh, they're already out. Wow.
Judge?
Yes.
I know you spoke to client about the selection of punishment.
Mhm.
Before the panel comes in, I think you need to make a
Okay,
record.
sure.
Give us a moment, Judge, because we don't trust him, he's a runner.
Okay.
So.
All right. Thank you very much.
Coming at the last meeting.
I think it's a good.
Excuse me, who do you all have? What's your name, sir?
Ernesto Hernandez.
And are you on the docket today?
Yes, ma'am.
All right, so this is what's happening. Your attorney said that they were going to call us to let us know when was a good date to reset you. Are you in contact with your attorney? Do you have good contact with your attorney?
He was Thursday.
Okay.
They told me, he was gonna call me.
All right, so this is what we'll do. Ms. Ferguson, just give him a 30-day reset because this may involve a blood draw or something. What date? All right, we're going to give you March 31st. If for some reason your attorney does not like that date, he'll let us know.
That guy?
Not yet. Yeah, well, we just finished the conversation.
Judge, just to let you know, I mean, defense. Hey, Brent. Yes. Just to let you know, one of our investigators from the DA's office, just the jurors, talked to them, asked what was going on. They've been waiting for 3 hours. So just want y'all.
Oh,
both to-
I will let them know that
Okay.
it's on me.
Yeah, he just mentioned it to me. I just wanted to
Okay.
mention it to the court. The fact.
Yeah, I know what you're gonna say is, hold on.
Yes,
You expected to start testimony today?
it's 3 p.m. There's no way we can start testimony today. So that would be a no. You're welcome.
What?
Yes.
Okay, I was just making sure.
Judge just told us that we're about to start jury selection. We're not going to finish before the end of business. So we'll have evidence tomorrow. Well, I actually sent out another trial request for tomorrow for you and someone and Ashby.
This full-time college student doesn't realize the fix of this.
He said,
They didn't want to be. Oh, what? Train conductor. Works for Union Pacific. I mean, how many times do you get a train conductor?
All right, court is calling 2024 CR 010751 State versus Miles Fenton. Can I have parties announced for the record for the state?
Andrew Harris Sademan.
Defense?
Grant Hardy.
And Mr. Porter, you as well? All right, and is that your client, Mr. Fenton?
Yes, sir.
All right, and defense, have you received all discovery from the state and did you review with your client?
Yeah, sure.
Court will find that the state is in compliance with discovery. Is there anything we need to be placed on the record before the jurors are brought in?
Yeah, sure.
All right.
Hey,
Yes.
I talked to the defendant regarding his election as punishment. I tried to explain to him many times the difference between punishment by a judge versus punishment by a jury. He either didn't understand.
Well, here's my question. Has it been explained that he needs to do an election for punishment?
Yeah, sure.
All right, and has it been explained that if he does not choose an election for punishment, that if he were found guilty, then punishment would come to the court?
Been explained many times, Judge.
All right, thank you. All right, let's bring the jurors in. Sorry. Thank you so much. Yes, thank you.
Yes. First row. Number 8. Make it roll. On the bench. Decline. Next one. Use this one.
Your number, so you might want to grab some underneath.
Oh, it's bad. All right, everyone, please be seated. All right, ladies and gentlemen, just so that you know, whenever we have jury trials in this court and really in any court, there's never just one case that is set on the docket. Usually there are a lot of cases set on the docket. So this morning, I believe we had about 60 cases set. So that's why it took some while, and that's why you were standing in the hallway. So that's not the state's fault. It's not the defense attorney's fault. It's really not anyone's fault, but if you want to blame someone, you can blame me for standing in the hallway. So everyone, with that being said, good afternoon. Well, that's lazy after I gave you guys an explanation. Good afternoon, everyone. We're supposed to be excited for jury duty. All right. So what I want to tell you is you are in the 187th District Court, which you guys should know, on the 4th floor because you've been standing out in the hallway on the 4th floor. I'm Judge Boyd. What floor are you on? 4th. What's the court number? 187. Who's the judge? Now you're probably asking yourself, what? Will she move it along because we've been standing out in the hallway so long? The reason why I ask that is because sometimes we'll take breaks, and when we take breaks, you all have to leave the courtroom. And believe it or not, people get lost. We've had instances where people have been trying to be selected on another jury panel, and then the deputy has to walk around to try to find, and everybody's calling downstairs in the basement, wondering where a particular juror is. So to my left is the court reporter. You all can make her job so much easier if you do two things for me. One, speak up. Well, actually 3 things. Speak up so that she can hear. Number 2, only talk one person at a time. And then this is the 3rd one that no jury panel has been able to follow, but I have faith in you. I've said that to every panel and my faith has been misplaced. But I have faith in this panel. I can just see it in your eyes. So this is what I would like for you to do. Everyone, please raise the white cards that you have. When I tell you to lower your card, lower your card. So jurors 1 through 21, lower your card. If your card is still in the air, which it should be, except for those numbers I've called out, to make the court reporter's job easier, whenever you speak, just stand, because the acoustics are very bad in this courtroom and she won't be able to hear, or at least it will be difficult for her to hear. So can everyone promise me that you will do that? Yeah. All right, you can lower your cards. All right, this case is the state of Texas versus Miles Fitten. If I could have parties introduce yourselves to the panel, please.
Andrew Harris Salem for the state of Texas.
Megan Galloway for the state of Texas.
Grant Hardy for mine.
Good afternoon, ladies and gentlemen. I'm Ronald Porter.
Thank you. All right. Does anybody recognize any of those parties who've just been introduced to you? If you do, raise your card. Now, the charge in this case is unauthorized use of a vehicle for count 1, and count 2 is theft of property, $25,000 to $30,000. This is what I will tell you. When the state and the defense speak to you, they will only be speaking to you in hypotheticals. Neither the state nor the defense can tell you what they think the facts are in this case. The only way you will know what people believe the facts are in this case is if you are on the jury panel. So when they speak to you, don't be in the back of your mind saying, oh, so that's what happened in this case. They're not allowed to tell you. They're only allowed to speak in hypotheticals. Does everyone understand? Yes. Now, indictments. Indictments are the way cases are brought to felony courts in Texas. What is an indictment? It's just a piece of paper to tell somebody what they're charged with. because it would be a sad state of affairs if you came to court and nobody told you what you were being accused of. For example, and let's practice raising our cards. How many people who have ever had a traffic ticket? Now that has occurred in every panel I've had. We have horrible drivers, but that's okay. That has happened with every panel. I've had a traffic ticket before too, once in my lifetime. I want to say I was maybe 19 to 21. So here I am, 22 years old, and that's the only ticket I've ever had. Okay, that laughter should not have been that loud. It should be, oh my gosh, she must be a genius. So when I got my traffic ticket, it was at that time where an officer had a paper book and they would write on it, and then they would give you a copy of the ticket. Now, my understanding, they do something electronically and it prints out. Well, let's say you receive a ticket and they say you didn't follow the yield sign, which I'm understanding people don't know what a yield sign means. So let's say you get a ticket for a yield sign. When you accept that ticket from the officer, you're not saying, oh yes, I didn't follow the yield sign. That's just a piece of paper to tell you what you're being accused of. And if you decide to go to trial on that, you're not going to be surprised when you go to municipal court and they say, oh, it wasn't for a yield sign. It's because you ran a stop sign. That piece of paper in that case and the indictment in this case cannot be used for anything by you to pass guilt. You are not to consider it. You are not to take it as an evidence of guilt or an evidence for anything. Does everybody understand?
Yes, ma'am.
Is there anyone here who's going to hold it against Mr. Fenton because there's been an indictment? If you are, raise your card. Next thing I want to talk to you about is the right to remain silent. Everybody has the right to remain silent in criminal cases. You don't have to testify if you don't want to testify. It's your choice. What I can tell you is this. I've been a defense attorney. I've been a prosecutor. Sometimes as a defense attorney, I would tell my client, one, your story's already been told. Are you going to say anything different? The answer sometimes will be, well, no. Then why do you need to testify? Sometimes it would be the fact that I believe the state didn't prove their case. You don't need to testify. Sometimes I would have clients who were extremely nervous to testify, and I would tell them, look, it's not going to look great for you because you're nervous just talking to me. So there are many reasons why somebody may not want to testify. The thing is, you can't hold it against them because our Constitution says that you have a right to remain silent. Sometimes people will say, well, if that were me, I would get on the witness stand to testify. And I always would tell people, you know what, but it's not you, so it's easy to say that. And you don't have a professional sitting next to you saying it will probably not be in your best interest. So the key thing is, if Mr. Fenton decides not to testify in this trial, you can't consider it for anything. You can't be like Mrs. Kravitz from Bewitched, wondering about what he would or would not have said. It is not to be considered whatsoever. Does everybody understand?
Yes, ma'am.
Is there anyone here who can't do that? If you cannot do that, raise your hand. Is there anyone here who's going to hold it against him or use it as evidence in any type of way? All right. Next thing I want to talk to you about is burden of proof. In criminal law, the burden of proof is proof beyond a reasonable doubt. What does that mean? When I was in law school, you had to know the definition. I knew the definition backwards and forward. I knew where to pause for a dramatic effect. See? I knew where to put the exclamation point. I had my first jury trial. I said it, I didn't stumble. I was so proud of myself. And then the next jury trial I had, there was no definition. So there is no longer a definition for proof beyond a reasonable doubt. So neither the state nor the defense can tell you what that is because it doesn't exist anymore. So I would think to myself, how am I going to explain this to the jury? I want them to hold the state to the proper burden. And then I said, let me explain it to them by telling them what it's not. Next door, we have the courthouse, the historic courthouse. That's the courthouse with the green rooftop. They handle civil cases over there. So one of their burdens is proof by preponderance of evidence. More likely than not, something happened. If you are ever on a criminal case, be it a misdemeanor case, felony case, but it's a criminal case, and you're deliberating in the back and you're saying, oh, where there's smoke, there's fire, or you're saying, I think more likely than not this happened, you are not at the appropriate burden of proof, because that burden of proof is a proof that's less than proof beyond a reasonable doubt. The other burden of proof they have next door, which is their highest burden on the civil side, is clear and convincing evidence. Proof beyond a reasonable doubt is higher than that. Does everyone understand?
Yes, ma'am.
Now, when we talk about proof beyond a reasonable doubt, that doesn't mean that the state has to prove their case beyond all possible doubt. It's just reasonable doubt. Do you have a doubt? Is it reasonable? If it's not reasonable, then it's not reasonable doubt. Does everyone understand?
Yes, ma'am.
All right. Now, fairness. I want to talk to you about that, because sometimes people will say, are you biased against someone? Can you be fair? What does that really mean on the criminal side? Sometimes the state or the defense will give you this hypothetical. And this is the hypothetical. You've been called up for jury duty. You're so excited about it. You've planned your routes downtown because you know there's a lot of construction. You've given yourself like 2 hours. You get up early, you go downstairs, you get ready to get in your car, and you're thinking, beautiful day. I can stop and pick up some coffee because that's how much time I've padded myself. Then you go to your car and you see that the windshield has been broken. You look inside, somebody has burglarized your vehicle and it's on cinder blocks. You're saying like, you know what? But I'm still going to come down and do my service. So let me call an Uber or taxi or take a Via or let my neighbor bring me down. You come down. You're standing out in the hallway for 3 hours, maybe. And you come in and you find out you're about to sit on a trial for burglary of a vehicle. And then people will ask you, can you be fair? So what does fairness mean? Fairness means that if your vehicle had been burglarized and you're called to sit on a burglary of a vehicle case, that means that you won't be looking at the person who's accused and saying, yeah, I'm ticked with somebody burglarized my vehicle, so I'm not even going to really listen to the evidence in this case. I'm just going to find that person guilty. So all fairness means is, will you be able to sit and listen to whatever evidence that is presented to you and make a decision, if you can, on whether someone's guilty or not guilty based upon the evidence that you hear? Does everyone understand?
Yes, ma'am.
That's all fairness is. Nobody, as my grandmother would always say, nobody was born yesterday and slept all last night, and you're just coming here with nothing that has ever happened to you in your life. Now, there are 2 phases to a trial. The first phase, people call it the innocence phase, but it's really not that. The first phase is somebody guilty or not guilty? If you find somebody not guilty, there's no second phase, because the second phase is the punishment phase. Everyone who's charged with a criminal offense must make a decision on whether they would come to the jury for punishment if they were found guilty, or come to the court for punishment. By them electing or selecting who they would come to for punishment doesn't mean that they're saying they're guilty. It's just that's what the law requires. Does everyone understand?
Yes, ma'am.
In this case, if Mr. Fitten were found guilty, the court would decide the punishment. Is there anyone who's going to hold it against Mr. Fitten because if he were found guilty, the court would determine punishment? All right, now the next thing I want to talk to you about is police officers. Usually in criminal cases, police officers will usually come in to testify. Here's the big question. Whoever comes in to testify, would you be able to judge their credibility just based upon listening to the testimony, reviewing the evidence, and perhaps viewing them? Is there anyone who can't do that? Is there anyone who is going to say, you know what, that's a police officer, so I'm just automatically going to believe what they say is true? Is there anyone who feels that way? All right, the next thing I want to talk to you about is who has the burden of proof. In criminal cases, the state always has the burden of proof. They have to prove each and every element beyond a reasonable doubt, and that burden never shifts to the defense. So the defense doesn't have to prove anything. In law school, they would always tell us that you can sit over there, play Monopoly, go to sleep. And the reason why they were saying that is because you don't have to prove anything. I don't expect either of these attorneys to go to sleep. I don't expect them to be playing video games. But that's just so you know, the burden never shifts to this side. So if you find yourself deliberating and saying, well, I wonder why I wonder why the defense didn't bring this specific piece of evidence, you know you've shifted the burden. The burden remains with the state. Does everyone understand? All right, now, the next thing I want to tell you, I love languages. I'm originally from Louisiana. I took the language that I knew I was going to need and use. So, of course, that's French. That's not Spanish. So, is there anyone here, raise your card if English is not your first language? All right, and keep your cards raised until I call your name. 7, 27, 30, 44. There's somebody who has their card turned a little sideways. 52, 58, 59, 61, 75. Number 7, what is your first language?
P.
I'm sorry?
It's called P.
How do you say hurry up in that language?
Plantain.
All right, thank you. Have you been able to understand everything that's been said?
Yes.
All right, thank you. You can have a seat. I always ask that question because I went to school with students who spoke 8 languages. So I can probably say hurry up in every language. That's all I can give you. Number 27.
Skizzy. As in G-I-S-S-I, Gizzy.
All right. And have you been able to understand everything?
Yes, so far, Judge.
All right, thank you. Number 30.
Spanish.
Have you been able to understand everything? Thank you. 44.
Arabic.
Have you been able to understand everything? All right, what does not that much mean?
Like some terms I didn't understand.
All right, what terms?
Some words, kind of.
All right, and how long have you been in the United States?
Well, I was born here, then we went back to home. And I came about 3 years.
I'm sorry, you're gonna have to speak up.
3 years ago.
All right, thank you. Number 52.
Language is Spanish.
Have you been able to understand everything?
I tried.
All right, how long have you been in the United States?
21.
21, or did you say 31?
21 years.
21 years you've been here? All right, thank you. Number 58.
Spanish.
Have you been able to understand everything? All right, number 59.
Spanish.
Have you been able to understand everything?
Yes.
61. Have you been able to understand everything? How long have you been in the United States? 16 years? All right, thank you. Number 75.
Spanish.
Have you been able to understand everything? All right, thank you. All right, I'm going to tell you all 2 stories. They're both true. I know that jury duty, people say it's difficult. I always tell people jury duty is an inconvenience. It's not a sacrifice. Your country only asks 2 things out of you. 1, to pay your taxes, and to serve on a jury once in a blue moon. Raise your card if you've ever served on a jury. So you look around, you can see how many people who have actually served on a jury. You can lower your card. And so what that means is many of you have not served fully on a jury. And it's not as though your country is calling you up every 30 days to serve on a jury. This is what I call a sacrifice. My uncle grew up in a small town called Grand Cane, Louisiana. Super intelligent. It's back in the day where all the teachers knew their students and they followed them from grade to grade, so they knew everything that they were doing. Well, my uncle, his teachers would send him to the next grade. They tell my grandmother, we've taught him all we can teach him. He's very intelligent, good luck. His siblings didn't like that because when they started school after him, the teachers would say, we're expecting a lot of you based upon your brother. So he ends up graduating from high school and the Vietnam War breaks out. He goes to my grandmother and he said, because of the way things are with civil rights and everything else, I can't improve my lot here. So he asked for her to sign for him to go to Vietnam. That was her firstborn, and she signs for him to go to Vietnam. And for the young people, that was back in the day where you only had 3 stations, ABC, CBS, and NBC. And you really couldn't count on NBC because if the weather wasn't just right, you were not going to get, programming. And this whole thing where you have 24/7 television, you could always turn it on. That wasn't the way it always was. At a certain point in time, they would play the national anthem and your television would go off. There was no more programming. My grandmother did have a phone, and that phone wasn't a rotary or touch tone, which I know young people, you don't know about the touch tone or the rotary. But how you would dial out is you would pick up the phone, an operator would answer, and you would tell that operator who you would like to be connected to. That's why you would have songs like Beechwood 45789. My grandmother sent her firstborn off. Nobody really knew where Vietnam was. My grandmother had a 6th grade education, but she was super intelligent, taught me how to read, write, and tell time. And she knew his number, his service number, what to put on the envelope. And you put it in the mail. This whole thing where you all have computers and people are posting photos and memes of cats eating, they didn't have any of that. You put a stamp on it and you wait for it to return. My grandmother quickly learned that the one thing you did not want is you did not want the military knocking on your door because that was not good news. So I tell everybody that's a sacrifice. What we're doing here, you're standing in the hallway, which I'm sorry you had to stand in the hallway so long. Those are all inconveniences. So, and people always tell me, you didn't tell us what ended up happening with your uncle. Did he make it back? My uncle did make it back from Vietnam. So that was a great thing. Both he and my grandmother and 2 of my aunts have since passed. But I tell that story to let people know that this, yes, it's an inconvenience. Yes, everybody wished they could be somewhere else, but this is something that your country is asking for you. They don't even have the draft anymore. And unless they start that again, you don't have to be drafted. The other story I want to tell you about is my friend who had jury duty. She did civil law. On the civil side, no slight to civil attorneys, but usually people who practice criminal law, they're in court every single day. She got called up for jury duty. She wanted me to have lunch with her. I said, that would be fantastic. We have lunch. And I asked her, how is jury duty going? She's like, fabulous. Now that I'm judge, I think about it. How could it have been fabulous? You're not with me in jury selection, right? So we talk and I said, why do you say it's going fabulous? She's like, oh, because I'm not going to get selected. I'm on the back row. I'm keeping my head down like in law school. I laugh. I tell her, this is so exciting. She says, why? I said, because we're going to be able to have lunch all week. So other than raising your card saying, please put me on this jury, the quickest way to become a member of this jury is if you're quiet. That's a true story. And I say that because both sides are only going to have 20 minutes to talk to you. So please, if you have questions, raise your hand. All right, State.
How many of you are familiar with Al Pacino from the early to mid 90s? Talking about Scent of a Woman, Heat, Devil's Advocate. Raise your hands. Okay, number 4. I want you to give me your best early to mid 90s Al Pacino impression. Terrible. Stop. 19.
I can't, but I can see it, but I can't.
I love it. 20.
I don't remember any of the scene. I know I watched it.
What's your number? Can you give me your best? Because one of the things that we really run into a problem here is that panel members speak, but the court reporter can't hear. So I want you to get into the Al Pacino mindset. So that when you get up to give us an answer, your answer isn't, well, I don't know. Your answer is, give me all you got. Something like that. So, is someone brave enough to try? Al Pacino. Al Pacino. Hooah! Hooah! That's the sort of energy that we'd like to have from all of you. Now, one of my favorite subjects is etymology and the study of the origin of words. How many of you are familiar with the word bias? You're 29?
Yep.
Okay, where do you think it comes from?
I would assume either Roman or Latin.
Could you stand up?
Yep. I would assume either Roman or Latin.
You assume wrong, have a seat.
Okay.
It comes from a game that was played in Norman France in the 8th century, and that game was called Biaise. Spelled Biaise. And that game was a little bit like bowling, except it was played with an oblong ball. So that when you rolled it, it rolled to one side or the other. It favored one side or the other. The Romans, not the Romans, the Norman French invaded England and conquered the Saxons. They brought their game with them. Its popularity spread, and gradually over time, we came to associate the idea of this game of favoring one side or another to mean favoring one side or another in anything. And that's how we get the word bias. And the reason that I bring this up is because bias in and of itself is not necessarily a bad thing. It just means favoring one side or another. So I'm not particularly concerned with what your biases are. It's not my job to judge your viewpoints or opinions. The reason we want to know what those biases are is because we want to be able to decide who can serve on this jury. Because if you favor one side or another, it doesn't really matter which side that is, you should not serve. So, this is a 2-count indictment. One of those counts is unauthorized use of a motor vehicle. One of those counts is theft of property with a value of at least $2,500, but not more than $30,000. So what does that mean? It means that there are 2 offenses that the state will seek to prove. 1, the authorized use of a motor vehicle. 2, the theft. And it means that we will need to prove to you certain things for each count. For example, for the unauthorized use of a motor vehicle, we'll need to prove that on or about a certain date in Bexar County, Texas, the defendant intentionally or knowingly operated another person's motor propelled vehicle without the effective consent of the owner. For the theft, we'll need to prove that on or about a certain date in Bexar County, Texas, the defendant unlawfully appropriated property with the intent to deprive the owner of that property, and the property had a value between not less than $2,500 and not more than $30,000. So what do all of those words mean? Let's start with appropriate. Juror number 34. Stand up, please.
I guess it means appropriate that if you had permission to use it.
Well, I mean appropriate in the sense of acquire, take.
Oh, well, I guess, breaking in, or if he had the keys, sort of a thing.
Fair enough. Have a seat. 42. What does it mean to you?
I don't know.
Fair enough. By the way, I want you to keep in mind, I don't know is a perfectly acceptable answer. Just say it like Al Pacino would, okay? Appropriation essentially means to take something or to exert control over it. But appropriation in and of itself is insufficient to prove theft of property. For example, juror number 21, hold on this one. Thanks. He appropriated my property. Okay, he now exercises control over it, but he hasn't done anything wrong. Why? Juror number 57, 60, my apologies. Stand up.
You handed him the bid and said, here you go.
Exactly. I gave it to him. It was with my permission. You mind if I have that back? Thanks. So appropriation of property in and of itself is not the crime. It's when the appropriation is unlawful. And how do we know when appropriation is unlawful? Juror number 44. You know what? Never mind. Have a seat. I apologize. 45. 45, stand up.
I didn't understand the question.
That's fair enough. 46, your turn.
Can you repeat it?
Sure. How do we know when appropriation of property is unlawful?
You didn't know? You took it?
Have a seat. Juror number 14. Can I catch you unawares? Sorry. If you don't want to answer the question right now, that's fine.
Just acquired by any process unknown to the owner of the property.
How about you, 13?
There's no consent by the owner.
Bingo. When the owner of the property does not consent to it being appropriated, then it's unlawful. So, let's try this again.
Yes, sir.
Who's gonna hold it out? I want you to. I didn't tell you could take it. But that's fine.
Yes, sir.
We took the pen without consent. That made the appropriation unlawful. I'm gonna let it slide for now. But even that's not enough. Because what if I just left it right there? Or even worse yet, what if you found it on the street? Would it be unlawful if he just picked up something that he thought was abandoned? Juror number 3.
I would say no.
No, why?
Well, because you don't have possession of it. Nowhere near you.
Juror number 18, what about you? What do you think?
Yeah, it's not because you don't know who the owner is. It's just sitting there in a public place.
Right. We think it's abandoned property. Nobody exerts ownership of it anymore. No one believes it's there, so pick it up, we take it. If you have a really good heart, maybe you'll give it to a lost and found, but otherwise, you'll think of it as yours. Now, when is intent to deprive the owner of property unlawful? How about 55? Sure. When is intent to deprive the owner of property unlawful?
Is it similar to what we said earlier without not having their consent?
No. It's when you don't have consent, but there's something more to it. How about 54? What do you think? Doesn't belong to you. How about number 28?
Well, when I think of intent, it's like you're kind of knowingly wanting to deprive that person of it.
So, in the example of picking up a piece of property from the middle of the street, we believe it's abandoned. We believe that nobody owns it anymore. That's why it's in the middle of the street. But with the intent requirement, we don't believe that. We know that it's still the property. Or we believe with good reason that it is someone's property, but we take it anyway. Now, that's just one offense. How about Motor vehicle. Panel member 10, it's a motor vehicle.
Motorized vehicle.
Okay. It's a car. What makes a car a car?
Wheel, motor, and run.
It has a motor. Stand up. What's your
Does
number?
29.
Okay,
Doesn't a motorcycle count as a motor vehicle as well?
very good. Any other motor vehicles that we can think of? How about panel member 68? I haven't picked on you yet.
Maybe a golf cart?
Could be. How about panel number 43?
Maybe like something aquatic, like a
Jet ski.
Yeah.
Jet skis are pretty cool. 29.
29. It would be anything over a 200 cubic centimeter engine.
Oh, that's pretty fancy.
I don't know if that's correct, but
You don't know if it's correct, but you said it counts. I like that. So it can't be just any vehicle that has been unlawfully appropriated. It needs to be one with a motor. How about operate? Because the unauthorized use of motor vehicle statute says operates another's motor vehicle. Let's see, 69, haven't picked on you yet.
Operates would be like you're in command of control of the vehicle, like you're the one who's directing it where to go, and how fast it's going, stop, go, all that.
Panel member 40, stand up. What do you think of what panel member 69 said? Do you agree or disagree?
I agree,
Okay, what?
because you're operating the vehicle, you're in control of it.
Right, you're exerting control. You're exercising authority. Now, how do we know when someone operates a motor vehicle? Panel number 17,
Sitting in the seat, front seat,
sitting in the seat.
behind the wheel.
How about panel member 31?
It's when you actually operate the vehicle and actually give it command what to do.
Okay, please have a seat. How about panel member 63?
I would say like keys in your hand, turning on the car, using it, not necessarily has to be driving, but
Fair.
operating it.
Fair answers. What are some signs that someone was not operating a motor vehicle? How about you, 15?
When a vehicle is stationary, not being moved at all, or turned on.
Okay, now I'm gonna come back to you, 14. Do you agree or disagree with 15?
Disagree,
Can you please explain why?
because it doesn't necessarily mean that they weren't trying to operate it, but that they were trying to get to that point.
Okay, fair enough, have a seat. And this brings up a good point. It's not enough that the state proved that someone was trying to operate the motor vehicle without the effective consent of the owner. We need to prove that they actually did. So if, as during panel member 14 says, we only prove that they were trying to do it, well, then we haven't met that burden. And if we haven't met that burden, then what does that mean? Panel member 49.
Means you haven't proven it with logical, coherent evidence.
And what does that mean for your verdict?
You don't have a verdict yet. You're incapable of a verdict.
So close. Panel member 39.
He would be innocent of the charge.
That's right, because if we haven't proven an element of
5
the
minutes.
offense, then that means the defendant is not guilty of the offense, because we need to prove every element. So what is effective consent? Panel number 12.
I don't.
You don't know. That's, again, I don't know is a fair answer. How about 11? How about 8?
Verbal or written permission to do or use whatever the person gave you permission to use.
Sure. How about you, panel member 6? What do you think of that?
Something similar, verbal or written expression.
Okay. Let's say that I give this pen to panel member 21. Panel member 20 doesn't know that I gave it to 21. 21 then gives it to 20. Would panel member 21 believe that he has the effective consent of the owner? Let me see. Panel member 34.
Okay, who owns the car? Do you own the car?
Well, I'm saying pen, but whatever, we'll say car.
Well, in my opinion, a pen and a car is two totally different things.
They are, so let's
Okay,
say car.
so go through it again.
Okay.
You own the car?
I own the car, I give it to panel member 21.
Okay,
Panel member 20 doesn't know that I gave it to 21. Panel member 21 then gives it to 20. Does panel member 20 believe that he has the effective consent of the owner?
if he knew whose. If he knew that it was yours,
How would he know that?
well, I don't just go get in a car if I don't know whose car it is.
Fair enough, have a seat. Panel member 41, what do you think?
I would say no, because he didn't know that.
I'm sorry, I can't hear you.
No.
Okay.
Because he doesn't know, that's what you said, right? He
Yes,
doesn't know that he got the permission.
but does he have a reason to believe that 21 doesn't have it with my permission? Or that he needs anyone else's permission at all?
I don't know, I don't know that.
All right, that's
What's your
fair.
number? Oh, 41?
Who agrees with panel member 41? Please raise your cards.
Can you restate it?
Yes.
You restate it. What are we agreeing?
In the scenario that I described, does panel member 21 believe that he has the effective consent of the owner?
Yeah.
Okay. Who believes yes? Raise your card.
Are you asking if 21 has the consent of you
No.
to give the pen to someone else?
No.
Or are you asking if 20 has?
I'm asking if 20 believes that he has the effective consent of the owner. If you
It
believe
depends how
yes,
you-
raise your hand.
It depends how you quote it, because if I was 20, I wouldn't take the piece, because I don't know who vehicle it is.
Fair enough.
Number, please.
All right, let me pause because everybody is whispering in the court and I'm pausing your time. You have 1 minute and 16 seconds. Everybody is whispering and the court reporter can't hear and I can't hear.
Okay. Your answer was yes, 20 has the effective consent of the owner. Raise your card. Okay. 2, 3, 5, high, raise them high. 5 through 7, 10, 13 through 15, 17, 19 and 20, 25, 27, 28, 31, 32, 35, 36. And when I call the number, you can put it down. 42, 43, 40, you got it, high. 40, 46, 48, 45, 53 through 56, 58 through 60, 62, 66, 70, 69, 73 through 75. How much time I got, Judge?
18 seconds.
I am scheduled for jury duty tomorrow in a civil court. So I sympathize with all of you, but I hope that for those of you who are selected, you have a good experience. Thank you.
All right, defense.
Oh, my name again is Brent Hardy. And
Mr. Hardy, do you have your microphone on?
But it's in the film.
I'm not as smart as Andrew, so I'm not gonna ask these complex questions. I do have a couple of questions with respect to the uncertainty that existed. At the end of this trial, obviously, you're gonna have one of three conclusions. Either you know he's guilty, you know he's not guilty, or you're somehow unsure. Does anyone know what you do if you're at all unsure about what the verdict should be? Number 55, please.
Say innocent until.
Precisely.
All right, so here's the thing. Let me pause it. I don't know. Everybody's whispering. Court reporter cannot hear. I'm looking at her real time, which is showing me what she's typing, and she's struggling a little bit because everybody is whispering. Talk the way you're outside or you're screaming to stop somebody from running in the middle of the street. All right, you may proceed.
You're exactly right. Any uncertainty, the fact is, if you're unsure, the verdict is not guilty, because any defendant is presumed not guilty at the outset. I want to draw your attention to something the judge mentioned, bias. Believe it or not, there are some circumstances in which you have a duty not to serve as a juror. There are two types of bias. One involves activities in which you may participate or particular interests you may have. Say, for example, you're active in promoting animal rights. You're an animal rights activist, and you're called in for jury duty in a case involving cruelty to animals. Is there anyone here who thinks you would be a good juror for a case like that? I agree. There are also cases where you have personal experiences that would make you unfit for a jury. I'll tell you a personal experience of mine. When I was in college, I had a 15-year-old sister who was killed by a drunk driver. It was beyond devastating. But to this day, I would never permit myself to serve on a jury involving drunk driving. I could not be objective. And this leads me to another important issue that, again, the judge touched on, as did Andrew, I think. It's beyond a reasonable doubt. Beyond reasonable doubt is a burden of proof. Juror number 16, can you tell me what a burden of proof is?
In my opinion, it would be that all the facts are laid out and having to make sure that everything is in order to prove that person is either innocent or.
Well, you're on the right track. If you think about it, it's a standard that has to be met. It is a burden, depending upon the burden. It's how high of a hill, how serious an obstacle the state must overcome before reaching the other side. There are several types of burdens. There is in criminal law, there is the reasonable suspicion that an officer, police officer might have, there's probable cause. In court, as the judge mentioned, you have preponderance of the evidence in a civil matter. That just means more, that it just means that the person more likely did it than not. He probably. And in child custody cases, you have to show clear and convincing evidence, which is an extremely high burden. But criminal law imposes the highest burden of all, beyond a reasonable doubt, higher even than clear and convincing evidence. So let's consider, what is reasonable doubt? As the judge said, it's not defined. So, juror 67. Can you give me an example of reasonable doubt?
Well, say he's in the car and somebody had an accident and he jumped in the passenger side and said, I wasn't driving, but nobody else was in the car but him. And nobody was leaving the scene. That would be considered, I would think, to be reasonable doubt, because nobody else that could drive the car.
You think it would be a reasonable doubt as to who was driving?
No, because cover the driver himself, unless you, I guess, in case you were in a new self-driving car.
Yeah. Let me, thank you, you can sit down. Let me tell you, some of you won't remember this, most of you won't, I'm sure. In 1982, some madman was putting poison into Tylenol capsules, and sadly, 2 people were killed. So imagine, if you can, a hypothetical, just and I guess unimaginably large pill bottle with Tylenol. You want to give your child a Tylenol capsule, but you know one of those pills is poison. How many good pills would have to be in that huge bottle for you to feel confident beyond a reasonable doubt that it's safe to give your child this medicine? Juror number 16. I called on you, I'm sorry. 15.
Personally, I'm not taking that chance.
How high would the number have to be, hypothetically?
Trillion.
I'm sorry?
Probably like a trillion.
1 trillion to 1. Before you felt no reasonable doubt. Juror 21.
Yes, sir.
Would 1 trillion suffice for you?
No, sir.
How high would it have to be?
Between $1 million and $2 million. Depends. Every pill you take in.
That's lower than 1 trillion. So it would be around 1 or 2 million, you said?
Yes, sir.
Okay. And finally, juror number 47. Give me a number. Do we not have a juror number 47?
I don't have a number for that. Beyond a trillion, I don't know.
It would be higher than 1 trillion? And you don't know a number higher than 1 trillion, do you?
I'm sure it's not one. 2 trillion.
All right, well, thank you so much. Got me off track. There is another matter I want to touch upon before I ask you several questions. It pertains to the decision of a defendant not to testify. This is critical. There are several reasons, as the judge mentioned, why the defendant wouldn't testify. You understand that there are some people who simply don't express themselves well. I mean, nervousness frequently looks like guilt. And if that's the situation you're facing when you're in trial, then obviously you're not going to want to testify. Additionally, prosecutors, a skilled prosecutor, can frequently make an innocent man or woman look guilty. There's no question about it. But beyond all that, there is the simple fact that sometimes your lawyer will advise you not to testify. Is there anyone here who would want to testify in a criminal case, even if your lawyer recommended that you not? Everybody here would do what their lawyer said.
It depends on the case.
Please,
I'm
number
sorry.
42, tell me.
I would want to advocate for myself and just speak up. I would do it against attorney advice.
And number 19.
I would have to have all faith in my lawyer to do that. And at that point, since it's my life and it's my life, I think I would have to highly weigh if I think that I could do it.
So you might do it.
I might. I'm not saying yes, and I'm not saying no. I just think that I would have to explicitly trust my lawyer to not do it. And especially if I'm on trial, I would want my answers.
I once had a robbery case, just parenthetically, a robbery case in which I implored the defendant not to testify, and he insisted. I finally had his father write him a note saying, please do what your lawyer says. And that, only then was he persuaded not to testify. Had he done so, I'm convinced it would have been disastrous for a multitude of reasons. Let me move on to police. Is there anyone here who believes that police are always right?
Always right.
Always right.
I'm sorry?
You didn't know what you said.
Oh, is there anybody here who believes police are always right? Is there anyone here who believes that police never lie? So would it be fair to say that among all of you, there is a belief that sometimes police deliberately distort the truth? Is that fair? Anyone who doesn't share that opinion?
I believe we're all people, even if we're police, we're all people. We make mistakes or not. We're all people, we're one person. So sometimes we make a decision and sometimes and bad or good. So we all have a judgment day. So I believe we're people. So we make mistakes and sometimes we don't. So that's how I feel.
Would you agree that sometimes a layman's testimony would be more credible than that of a police officer?
I'm sorry, say that one more time.
Would you agree that sometimes a layman's testimony would be more credible than that of a police officer?
What does that word mean, lame?
Oh, I'm sorry, a non-police officer.
Okay, say it one more time now with the word.
Would you agree that a non-police officer's testimony would sometimes be more credible than the testimony of a police officer?
That could be right or wrong, pretty much what you're saying to me. Their judgment
Please
would be,
stand up.
I'm sorry, their judgment will be, what did you say again?
I'm
sorry.
just trying, no, that's all right.
I just want to make sure I made the right decision when we talk questions.
I understand. I'm just trying to understand if you would automatically trust what a police officer says on the stand more than you would trust what somebody else says on the stand.
To me, we're equal. So, I mean, I say we believe in what we see, what's right or wrong. So we have to believe on who's with the evidence, right or wrong. So to me, it's like I have to see what's going on with that situation before I can believe whoever does or not.
Thank you. Thank you. Number 22, please.
Police officers technically are experts in their fields. Police officers are technically experts in their fields. So even though they are subject to bias, they are like doctors. So you kind of take them as a reputable source. Yes, they can be incorrect, as she was alluding to. They are subject to their own biases, but I think they are the peacekeepers and the enforcement. So they should technically be taken at a greater value.
Thank you very much. Finally, I want to ask, is there anything else or anything at all that should be known about any of you that has not been brought out to date through the questionnaire or otherwise? Is there something that would make you less than an impartial juror? Juror number 20.
No. No.
Does anybody have any question as to their impartiality? Yes, number 69.
My only question, I work in the automotive career field in auto sales, so I would like to have a better understanding of where the vehicle was taken from. If it was like stolen from a dealership, that might irritate.
What makes you think the vehicle was stolen?
Well, we're here because of it's basically been said that he was operating a vehicle. The assumption is that it was. Right.
Assumptions are dangerous things. Wouldn't you agree?
Yeah.
There's been an allegation that somebody used a vehicle without the consent of the vehicle owner. Whether that is proven beyond a reasonable doubt, it remains to be seen. But I understand your point, and I appreciate you bringing it up. Anybody else? Y'all, thanks so much.
Excuse me, you have number 70.
Just hearing the improper use of the vehicle. So I was hit and had my car totaled by improper use of the vehicle prior. So just kind of biases, I guess, in that sense. And it was a sense of when I was younger, I saved up for 2.5 years for a car. 3 months later, I was hit 80 miles an hour by an improper use of the vehicle and it was totaled. And obviously, it's a reminder of the roads out there.
So the tender spot for you.
Yeah, it's like, I guess, interest rate or insurance rates are high down here in other states.
I don't know of any states where they're low. I'll pack my bag. Really?
Yeah.
That's
Yeah, I guess.
Yeah.
All right, and then you have juror number 10. Number 10.
Juror number 10. Yes, please. I don't mean to ignore you.
No, you're good.
I just I can't look in every direction. Go ahead, please.
So my husband has been trying to be law enforcement. He's gonna get hired. He's already been before and military prior to. So I don't know if that makes a difference or not.
Not to me. Does it make a difference to you? Do you still feel that you could be fair and impartial in deciding? In weighing the evidence of this case? That was a question, do you? You do. Good, thank you. Y'all, thanks so much. I appreciate it. And I wish you all the best of luck. I don't know whether that means good luck getting off or, no, but really, thank you very much.
All right, so ladies and gentlemen, this jury trial will probably be completed by Wednesday. So is there anyone who has any time constraints in that regards? All right, just raise your card. Everybody wants to stand now. Before there was no standing, even though I told people to stand. All right, number 1, after I call your number, lower your card. Number 10, 15, your card is backwards.
Sorry.
1, 5, 10, 15, 17, 19, 27, 30, 33, 36, 37, 38, 40, 41, 42, 53, 57, 59, 64, 75. Number 1, what's your time constraint?
Working out of town now,
Working where?
in Houston,
And when is this going to,
leaving it tomorrow or Wednesday?
did you let them know this downstairs?
No, ma'am, no.
Why not?
Because they said it was just something child-wise, if you had a child or you were over 70, 75, something like that.
All right, thank you. Number 5?
Judge, I'm an attorney and I had scheduled, I do administrative law, federal administrative law hearings, and I scheduled my 2 clients for our preparation tomorrow for 4 hours. And I wasn't sure how long this case would last, so since you raised it, that's I'm concerned about that. If I didn't have that, I do have a medical appointment on Thursday, but if it's over Wednesday, I'm fine. So,
All right, thank you.
yes, ma'am.
Number 10? I'm sorry?
I'm good.
All right, thank you. Number 15?
I have a flight booked on Thursday to Colorado, and just in case that it might extend over Wednesday, I just wanted to let you know.
All right, thank you. Number 17?
They said the evening classes don't matter, but I just missed my evening class from 4 to 4:50.
Okay.
So,
Is that by Zoom?
no, it's at UTSA.
All right. Oh, I teach at UTSA. I'll let them know.
Okay.
All right. All right.
Yeah.
All right, thank you. So when are your classes?
Sorry,
What dates are your classes?
Monday and Wednesday.
Monday and Wednesday. All right, thank you.
Thank you.
Number 19?
Same thing. I leave out of town on Thursday. So if we're done by Wednesday, I'm okay, but Thursday I leave out of town to Corpus.
All right, thank you. 27?
Your Honor, I came in here sick today. As you can hear from my voice, I'm in the flu. So I do hope to be able to see my physician. Not feeling well, really.
All right. I don't like when people come in when they have the flu. Did you tell them downstairs you had the flu?
No, I did not, Your Honor.
Why are you keeping that a secret from the people downstairs?
My understanding is they had said for us to be able to let you know that, Your Honor.
All right, Deputy Laura, if you'll send juror number 27 back downstairs and let them know he needs to be put back in the system. And he hasn't been, this doesn't count as his time of service. All right, juror number 27, can I see the statement of defense?
I was fine with
Thank you.
Also, I believe juror number 4 said that he had a thing.
Thank you. All right, and juror number 27, you can go back downstairs, keep your mask on and let them, Deputy Laura is going to send a notice to them that you're going to be up for service again.
Thank you, Your Honor.
You're welcome. Number 30?
Business owner, and I have clientele lined up for the next few days. I don't have employees that are under me, and I take care of those clients.
All right. Thank you. And somebody else over here, number 4? 12? All right, thank you. Number 33.
Actually, I take it back. I can attend for the.
All right, thank you. 36.
I'm self-employed and I work lined up.
All right, thank you. 37.
Hi, Your Honor, it's for childcare for tomorrow. I need to pick my daughter up by 3:30.
At what time?
3:30,
And how old is your daughter?
9.
She doesn't have her driver's license yet.
They don't make them like that anymore.
All right, thank you. Number 38.
To report back to work because. it's only
All right,
me
you
and the
need to stand.
Huh?
You need to stand.
I
38.
Report back to work because it's only me, the head custodian, to open the school in the morning.
All right, thank you. 40.
I have 2 school-aged children. I was able to find help today, but not for tomorrow or Wednesday.
All right, when is drop off?
Drop off is at 7:30 and 8:30,
And pick up?
3:15 and 4:20.
All right, thank you. Number 41.
Mine may or may not affect me. I have to take my father for a medical procedure on Wednesday.
What time?
I think I have to get him there at 8 in the morning, and I don't know the pickup. It's whenever his procedure's over. I have to pick him up and
All
get
right,
him home.
thank you. Number 42.
Yes, I have 2 littles. I just need to be out by 5, so as long as we're.
All right, thank you. Number 53.
I'm a pediatric primary care provider. My patient's on my schedule tomorrow.
All right, thank you. Number 57.
I need Wednesday, so I have a corporate event that I am a host for. I planned it and I have to coordinate everything on Thursday.
Is this Martha Stewart planning or you really?
Not quite.
Okay,
CEOs in the room and we ran a webinar and a luncheon.
okay, all right, awesome. Thank you. And you say that's when? All right, thank you. Number 59.
I'll be able to attend.
Thank you. 64.
I have a battalion meeting tomorrow and a mission to run a convoy on Wednesday.
All right, thank you. 75.
I am a single mom and I have to pick up my child.
All right, thank you. All right, everyone, this is what is going to happen. You are not excused yet, but what I'm going to need you to do is leave those white cards behind, take all of your personal items, and we're going to have you back here by no later than 4:50. It may be sooner than that. Just make sure you're standing in line. Look to your left, look to your right. You're responsible for that juror being in line. All right, everyone, please rise for the jurors.